Good morning everyone, my name is Sukhpal Chahal and I'm working as a registered migration agent with Aussizz Group in Adelaide, South Australia. Today's topic is what to do if you get a visa refusal or a cancellation notification from the Department of Home Affairs. In such a scenario, there are two options. Either you can lodge a merits review application with the Administrative Appeals Tribunal or a judicial review with the Federal Circuit Court of Australia. However, before you make a choice between the two options, I would like to let you know what are the differences and advantages of choosing one over the other. So firstly, I'll make a comparative analysis of the merits review with the judicial review. So merits review process is conducted by the executive arm of the government, whereas the judicial review process is conducted by the judiciary, or in other words, it's conducted through the court, Australia's court system, which in case of decisions made under the Migration Act will be conducted in the federal court system and not in the respective court systems. The merits review process looks at the substance of the matter, that is whether the facts of the case they fit the statutory requirements, whereas the judicial review process looks at the process by which the original decision was made, whether it was made lawfully or not. Then merits review, it takes the facts and law as they are at the time of review. It incorporates any changes since the original decision, and it allows you to introduce new evidence, and it's not bound by the original arguments that you had presented to the Department of Home Affairs. Whereas the judicial review, it takes the facts and law as they were at the time of the original decision, and you cannot introduce any new evidence, and you are always bound by the original arguments or the documents that you had provided to the Department of Home Affairs. The outcome of a successful merits review is a substitution of a fresh decision, which legally takes the place of the original decision. So the merits review process basically it takes into consideration the legality and the integrity of the whole case. Whereas the judicial review process, the outcome of a successful judicial review application is that the original decision is legally quashed, and the matter is remitted back to the original decision maker. That is, it goes back to either to the Administrative Appeals Tribunal or to the Department of Home Affairs, and then has to be either the tribunal member or the decision maker in the Department of Home Affairs have to make a fresh decision about your case. So it's basically the judicial review is it focuses on the legality of the case, or whether there has been any legal or procedural error in your case or not. And the last difference is that merits review process is much cheaper and faster as compared to judicial review, and the judicial review, obviously, because you'll be dealing with the court system, so it's more expensive and it takes more time. So when considering the advantages, of the merits review process, it's always our advice to our clients to firstly avail the merits review option and go for the judicial review option only if otherwise they are not satisfied from the merits review outcome. So after that, once you have made a decision of lodging a merits review application, the application needs to be submitted to the relevant division of the Administrative Appeals Tribunal. Fine. For migration related matters, like for example for visa refusals and cancellations, the applications they need to be submitted in the Migration and Refugee Division of the Administrative Appeals Tribunal. So for migration cases, then once you choose the division, then there are three different options there, whether it's a migration related matter or a refugee related matter or a character related visa decision. For migration, say for example, if there's a visa refusal or a visa cancellation decision under the Migration Act, or if there's a decision relating to approval or cancellation of sponsorship or nomination, for that you take the migration option. If you have got a visa refusal for a refugee visa or a cancellation for a refugee visa, then you take the refugee option. However, if you got a character related visa decision, then you take the character related option. Fine. So from where does the AAT draw its power? I just want to briefly let you know from where the AAT gets that power to make a decision on your application. So the AAT is an independent body and is not part of the Department of Home Affairs. It draws its power from the Australian Migration Act 1958, and it uses the rules and criteria that are set out in the Migration Act and the migration regulations. And the overall aim of the Administrative Appeals Tribunal is to review the decision as quickly and efficiently as possible and deliver a fair decision under the law. So now, with that background in mind, I'll take you through the merits review process. So firstly, at the time of merits review application, how do you apply for a merits review? So you can apply for a merits review online, or you can submit a paper-based application using the appropriate form through email, post, or fax at any of the designated AAT registries. And the AAT has got registries in Sydney, Melbourne, Brisbane, Perth, or Adelaide, and the addresses of which can be found on the aat.gov.au website. So, but care needs to be taken that these merits review application needs to be lodged within the given time limit that is set by the law, and that time limit is explained in the letter that you would receive from the Department of Home Affairs under the heading merits review rights. So normally for a visa refusal, you have a right to lodge a merits review application within 21 days after the date of the decision. And for cancellation cases, the department may not give the applicant any review rights. But if it gives, it would be very short, somewhere between 1 to 7 days. And applying for merits review within the given time period is very crucial, after which you will lose that opportunity, and the AAT has no power to extend the time limit to lodge an application for review. Then talking about the eligibility, whether you're eligible to apply for a merits review, in order to be eligible, you must be a person who is involved in the Department of Home Affairs decision and should be named in the letter. Usually this is the person who applied for the visa or whose visa was cancelled. In some cases, the application can be made by the person sponsoring the visa applicant. Fine. And the Department of Home Affairs letter will tell you all about this. So who can apply for a merits review? So merits review can be applied by the affected person himself or herself, or can appoint a representative to help you through the review process, and that person should be a registered migration agent with the Office of the Migration Agents Registration Authority. Further, what needs to be sent along with the appropriate form, along with the form that you'll fill up and send to the department, or if you complete an online application, you need to submit the notification letter that you received from the Department of Home Affairs. You need to send the decision record sent by the Department of Home Affairs in regard to your case, and any other additional information or evidence that you think can support your case. All the documents submitted to the AAT must be in English language, and any other documents that you have in other languages, they need to be translated by an accredited NATI translator. Along with the application goes the application fee to the AAT, and one needs to keep in mind that invalid applications won't be accepted by the AAT. So all the requirements that are to be met to lodge a valid application needs to be met before the AAT can acknowledge your case. So once you have applied for your merits review, the AAT will acknowledge if the application has been accepted. The AAT will then ask the Department of Home Affairs for your case file. The assigned tribunal member will review and have a fresh look at all the information and documentary evidence that you have submitted. While the application is under processing, if your contact details or postal address changes, it needs to be immediately updated with the AAT within 7 days. And the AAT's processing times at the moment, it's for different kinds of visas. Is, for example, for a bridging visa, it's taking 12 calendar days. For a family case, it's taking 626 days, which is quite a long period. For nomination or sponsored approval cases, it's taking 736 days. For partner visas, it's taking 738 days, which is quite long. For permanent business visas, it's taking 660 days. For skilled visas, it's taking approximately 315 days. And for student cancellations, it's taking 397 days. For student refusals, 580 days. For temporary work visas, 622 days, and for visitor visas, it's approximately taking 508 calendar days, and for all other kinds of visas it's taking 646 days in total. So that's the average calendar days from lodgement up until finalization of a case. So after having applied for a merits review application, the third stage is the invitation for a hearing stage, and that is when you have to appear before the tribunal. So this is a chance to present your case before the tribunal, and this could be conducted through phone, video conference, or it could be a face-to-face meeting. So before the hearing date, a response to hearing invitation needs to be submitted to the AET within 7 days of receiving the invitation letter to confirm your attendance at the hearing. An interpreter can be requested to the AET if you want that service, and it is free of cost. 1 week before the hearing date, all the supporting evidence along with the submission needs to be submitted to the AET for the tribunal member to review. And you could also take a witness along with you in the hearing to support your case. And so here I would briefly like you to explain about what a hearing is. So hearing is like an interview in an informal setting, and it forms an important part of your review. The tribunal member will have thoroughly read through your file from the Department of Home Affairs before the hearing date. And a hearing is an opportunity to talk to the tribunal member directly and give evidence and present your arguments to support your case. So preparation is essential to give yourself a best chance to get a positive outcome. Hearing is usually the final stage of your review, so you need to do your best at this stage. So migration review hearings, they are generally open to the public, but in some circumstances the person can request that the hearing be held in private. However, the refugee review hearings, they are always held in private. So it is during this stage when your registered migration agent's role becomes critical. As a representative of yours in a registered migration agent role, firstly, what we do is we identify the legislative basis on which the decision maker has made the decision to refuse or cancel a visa, and look into the reasons he or she has cited in the notification. Secondly, we see in coming to their conclusion, did the delegate or the minister take the required criteria of the respective visa into account? And then the threshold test for a merits review is that there is a decision which can be reviewed by the Administrative Appeals Tribunal. So it should be reviewable by the Administrative Appeals Tribunal. And the fourth step is that you need to have a standing. So for example, you need to check if you are the person whose interests have been affected by the decision of the delegate or the minister. Then after that, we assess that why the decision made by the delegate was not a correct or a preferable decision, and why a favorable decision needs to be made considering the current evidence before the tribunal. Applying the relevant law to the facts is the heart and soul of the client's case. This is where the registered migration agent demonstrates his or her skills by applying the relevant law to the facts, taking into account the departmental policies and the individual's immigration history and supporting evidence, and prepares a persuasive submission in a systematic way so that it is both convincing and easy for the tribunal member to understand the whole case and make a favorable decision. At the end of the hearing, what are the different kinds of decisions the tribunal can make? As in civil and criminal matters, you could expect a remedy or damages for the loss incurred. But in migration related cases, or in visa cancellation or visa refusal cases under the Migration Act, the tribunal member can either affirm the decision, which means that the tribunal agrees with the Department of Home Affairs decision to refuse or cancel a person's visa. The tribunal member can set aside the department's decision and make a whole new decision in regard to your visa. This means that you have been successful in your case, or else the tribunal member can remit your case to the department, and this means that the tribunal has decided that you meet one or more criteria for the visa. The tribunal member will send your file back to the Department of Home Affairs to reconsider its decision. Then the department may look into whether you meet all the criteria for the visa. However, if there's a fourth instance, you might, and that is if the AET has got no jurisdiction to make a decision. So sometimes the tribunal may decide it has no jurisdiction to review the decision. This means the tribunal has decided that it has no power under the Migration Act to review the decision. For example, if your application was submitted after the time limit, in such a case the AT will let you know as soon as possible, and then you won't have a hearing if it doesn't come under the jurisdiction of the AT. So clients need to be aware that the tribunal has the power only to review and change a decision made by the Department of Home Affairs, but it cannot grant a visa. Only the Department of Home Affairs can grant a visa. Then the last stage is, how will you find out about the decision? In some cases, the decision may be told by the tribunal member at the end of the hearing itself, whereas at times the member may also ask for more information before making a decision. Usually the decision is sent in the form of a written letter along with appropriate reasoning for making the decision. It's called the Statement of Decision and Reasons. If you have nominated a representative or an authorized recipient, such as a registered migration agent, the letter is sent to them. A copy of the tribunal's decision is also sent to the Department of Home Affairs. Once the tribunal member has made a decision, the review process is complete. You cannot submit any more information or evidence to the tribunal after that. The person's case is returned to the department for further processing in accordance with the decision made. If you have any questions, you can contact the tribunal office through the contact details provided on the notification letter. So if you're not satisfied with the AT's decision, you can lodge a judicial review application with the Federal Circuit Court of Australia on a question of law, but that has to be done within 28 days as per Section 44 of the AT Act. At the end, I would like to put a disclaimer that all the information that has been provided through this video is general in nature. For advice specific to your circumstances, please contact one of our registered migration agent by calling at the number given below, or by visiting one of our offices in Adelaide CBD or in Mawson Lakes, the addresses of which are also given below. I hope this video was informative. Thank you all for listening to this video.